Hey everybody, it's Kieran here. I'm sure probably some of you have heard my voice, but if you're not familiar with who I am, I'm the guy behind WP Radio that makes all of this stuff happen. And I really appreciate you guys taking the time to listen to all of these episodes. It's really great. We're seeing these numbers going up and it's fantastic. But the reason I'm recording this right now is because our lovely host Terry is away right now at work. And he didn't have time, and I didn't want to make him record these intros because I'm sure a lot of you guys saw he was working all day interviewing people. So by the time we were done, I just said to him, hey, we'll figure it out later. I wanted to give him a rest, and we had other things to go do, but he really, really worked super hard the day for the claims conference. It was awesome. We recorded 15 interviews total, so all of those will be coming out very, very soon. But right now, I just want to apologize and say that there should have been something that came out last week, and there wasn't because I went to Whistler, and I didn't have anything recorded, and I didn't have my mixer or anything on me, so I do apologize for that. I'm not going back there anytime soon, so that's not going to happen. My favorite thing and priority is podcasting and WP Radio and doing all of that great stuff. That being said, we have 3 episodes coming out this week. One, the one you're listening to right now. Tomorrow as well, on Thursday, there will be another episode coming out. And these are both from WP Live. And last but certainly not least, we've got the OIAA Trivia Show coming out later this week. And the reason I want to emphasize that so much is because we still do not have a guest for that show. And I want someone to email me as soon as they can when they're listening to either this episode or the next episode and tell me that they want to be on the show. Because the whole point of it is that we are trying to show our support and appreciation to our listeners and stuff. So if you can respond and be the first person to respond right away, or if you're the second person to respond and the first person doesn't win, we will 100% text you and have you on the show. And how that's going to work is you've got to listen to the past 2 episodes and these ones coming out now. All you have to pretty much do is retain that information, nothing too insane, but we're going to ask you a series of questions to make sure that you are listening. And if you do, you are going to win a pair of Toronto Raptors tickets, which is pretty insane right now because they're doing really well. The game you'll be going to if you win is the Minnesota Timberwolves versus the Toronto Raptors on Monday, February 10th at 7:30 p.m. So as soon as you're done listening to this, email me or pause it and email me right now at Kieran, spelled Kieran, at Doherty, Doherty. I'm sure you already know how to spell that one, 664.com. So that's Kieran at Doherty664.com. And I will try and see if we can squeeze you in for the show. It's basically going to be via radio call-in style, where we pretty much call you and ask you a series of questions. And if you win, you're going to get these tickets, which is pretty cool because you can take your significant other, you can take a friend. It's pretty impressive for you to say, I won these tickets on a show. So we're excited about that just because it's going to be a really cool time. But beyond that, I just want to say thanks again so much for everyone coming out to the claims conference last week. If you couldn't make it, it was a blast. Try and come to the next one because they're such great events and you can see how much everyone really cares about it. So on today's episode, we've got John Russell from Dye & Russell LLP and Michael Swinley from Templeman LLP, pretty much kicking off the first episode of our case law show. We both had John and Mike specifically come in for this interview, and it was really awesome to see them meet for the first time. It was just a great time all around. So the interview was great. You're going to hear a lot about what they were talking about, and mainly just what they plan on talking about for the rest of the year. That's really the great part, is it's a really good kickoff show. Thank you so much for listening, and we will be back tomorrow with another episode. Make sure you look out for that one, and once again, send me that email, and we'll get you on the OIAA Trivia Show.
All right, it's Terry Doherty. We're WP Radio Live. We're here at the Claims Conference, and I've got 2 great lawyers here with me. I've got Michael Swinley from Templeman, and I've got John Russell from Dye & Russell. John's our plaintiff lawyer this year, and Michael is our defense lawyer. And we're going to talk to them, get to know them a little bit here. And this is the new show. It's a podcast that'll be out once a month, and then we're going to have both lawyers on, and we're going to get a plaintiff perspective and a defense perspective. We've never done this before. This is new to the industry. We just typically shy away from having plaintiff lawyers and defense lawyers in the same room. Not sure why, but we've done that. But we're going to try something. We'll see. We don't come to punches. It'll be good. The great thing about the podcast regulars will be calling in, so if they disagree, they can disagree over the phone. But let's get to know you. Michael, just give us a little bit of your background and tell us where you're from and how you ended up at Templeman.
Sure, thanks, Terry. So I'm originally from St. Catharines, born and raised. Came to Kingston for law school in 2006, and if you've ever been to Kingston, you'll know why I settled there. It's just a wonderful city. I love the Eastern Ontario and the East region in general. So stuck around, was hired on as Templeman, and had the glory of articling under Brian Abrams, who's now Justice Brian Abrams, primarily sitting in Brockville, but throughout the East region. I was then mentored by our senior partner, Willie Meninga, who is now doing mediations, and became a partner 5-6 years ago now. I practice primarily in the area of insurance defense and in civil litigation. So primarily I'm doing defense work. If it's not insurance defense, I'm doing private retainer defense work and insurance defense opinions for various companies. I tend to do a lot of traveling on the road through the East region, as is the case with being out there. So my catchment area is typically from Port Hope all the way to Cornwall, and sometimes up to Pembroke and other northern areas.
Yeah, and I've gotten to know you over the years, and that's great. And I love working with your firm on the defense side and things. And let's get to know John. John Russell of Diane Russell and plaintiff firm. And John, tell us a little bit about you and how you got into law and where you started and how things came and how you became Diane Russell.
Sure, thanks, Terry. I've been doing it now for about 30 years. I started out on the defense side. You mentioned something before about you wonder why there isn't any plaintiff lawyers on this show, or why we don't commingle, I guess, or get together more often. And I think a big part of that problem is why I decided to become a plaintiff lawyer in the first place, is that I think there was room for a different approach. Being a plaintiff lawyer, having been a defense lawyer for such a long period of time, it's informed how I deal with things now. And I think it just starts from having respect for the other side. I understand the insurance companies. I respect them. I respect the lawyers on the other side. I don't come from it from a place of I'm going to be smarter than they are. I'm going to bully them into something. You come to them with a good case and a reasonable position, you can get things done. There's no reason that the adversarial system has to be so adversarial. It's kind of that's our approach. My background, dating myself a little bit, you can't see the gray hair on a radio, but doing this 30 years, where I started, people may not even remember these names, but Fireman Regan, kind of like the place to be back in the day in Toronto. There was a few other places after that, but doing our own firm now, the plaintiff firm has been about 16 years or 15 years now, so.
It's been a while.
It's been a while, so almost half and half now in terms of what I've been doing, but yeah.
And the plaintiff side is much different, right? You take, it's kind of an all-comers market kind of thing, right?
No, I would disagree with that. We're
good.
very picky about how we take our cases. We turn away people every day, actually, because we know what cases are worthwhile, especially when you're dealing with auto accidents. Obviously, you got to deal with the threshold. We don't want cases that aren't good. We want people that have real claims, basically, and then we're there to help them.
And what types of cases do you handle in your firm? And then I'll come back and ask you, Michael, the same thing.
Well, we handle all plaintiff personal injury. We do some medical malpractice, but again, we're very picky about that. I have a lot of friends that are doctors, so unless I have one of them vet the case and say that, yes, somebody's dropped the ball here, I don't want to be known as a firm that does medical malpractice for the most part. We take more serious cases. Motor vehicle cases are probably still the bread and butter, or the majority of the cases that we do, and then other various types of liability cases as well. So any injuries, but still mostly car accidents.
Okay, and Michael, on your side, what do you focus on? And then it's kind of is Templeman. I'm assuming Templeman's a full-service defense firm.
That's right. So Templeman's a full-service firm in general. So we are up to, I think, about 35 lawyers now, which places us as one of the biggest in the East region, certainly outside Ottawa. So within the civil litigation department, there are 4 or 5 partners and a number of associates that work in insurance defense, which is still probably our biggest area in general at the firm. And then within insurance defense, I mean, we cover the full gamut of insurance defense, be it bodily injury claims, property damage claims, professional liability, not-for-profit liability, coverage opinions, so various different lawyers in our firm specialize in certain areas. One of my partners specializes, for example, in disability insurance denials and travels actually all over the country doing disability insurance work. My practice focuses primarily on, your bread and butter insurance defense work, motor vehicle accidents, slip and falls and trip and falls, so general bodily injury, as well as property damage, which would include both, defense side property damage as well as subrogated work.
So I've got the right people then. So you both do auto, you do it for defense, and John does it for the plaintiff. So this is going to be a good podcast. So let's kind of. What do you think the topics we should cover this year? Let's get your opinion. What do you guys think? Do we want to go into AB, BI? Do we want to talk about the deductible in BI and how things are changing, or there's new regime coming in and changes? What do you think? What do you think people are going to be interested in?
Well, it's such a changing market, especially with auto, and I mean, I think one of the big topics we ought to cover is safer cars. What does this look like? Is there going to be a substantial auto practice in the next 5 to 10 years? You ask many a lawyer, and I know I'm seeing on the defense side, and many plaintiffs' lawyers tell me they're getting out of auto because they see the writing on the wall. I have seen more claims brought on the property damage or for professional liability by the usual plaintiffs' lawyers in the East region, who would typically focus on insurance defense, last year and this year than any other year. And all of them are telling me, we're getting out. So that might be one topic I think we could probably spend at least 1 or 2 podcasts on.
Yeah, I think that's an interesting topic. I'm not as doom and gloom about that as some people would be, because I think while self-driving cars are coming, it's definitely going to be a thing, and it's going to change things as it comes. You're never really going to get the situation where we have no issue until we have every car on the road self-driving. That's a long time away. I think we're 20, 25 years before that happens. But what it's going to be interesting, though, is we're going to have self-driving cars, and how does that affect it? I think you're going to have fewer accidents with them, but the ones that we do have are going to be a lot worse. So I think that's definitely an interesting topic.
So I got to tell you, I just got a new car. It's a company car, and the self-driving features in it are ridiculous. And I mean, my personal car, which is much more expensive and in the branding, it has way less features than my new company car. I mean, it literally has a self-driving feature. It has lane, it holds it, it's in its lane. I can literally put it in drive, put one finger on the car, and it'll drive from one end of Ontario to the other. It'll slow down, it'll speed up. It won't change lanes, so it's not an infinity, but it'll do everything but.
Well, I think the problem you're going to have now is that it's just what you said. People are going to get lulled into a sense that their cars can do more than they can, and you get into trouble as a result. That's what you're finding now. You're getting cars that are, people are driving around in Teslas that have the ability to self-drive, and so they'll actually let it drive, but it's not there yet. The technology's not quite there, and I think it's going to be a while in Canada too, because the snow and the dirt in the roads create problems for the sensors. So it's a great topic. I talk about this a lot. I think it's going to be very, very interesting, because how you mix these cars in with regular cars on the road. We're going to be now suing Microsoft. We're going to be suing the companies that make the chips. So everybody's going to be pointing fingers at everybody. It'll be interesting for the deductible, because arguably these are not people, does the deductible apply to Microsoft?
Well, that's why I'm wondering, right? You're taking it right outside the industry at that point, right? It's no longer an insurance matter. It's a civil matter. So does the deductible apply on one part of the claim and not on the other? And then the other thing is, how are you going to get these parties involved, right? Is it really Microsoft, or is it the software company that Microsoft worked with? I mean, it seems it'll be endless on who you're going to be naming.
Well, it's certainly an exciting time. And I mean, another topic I think we ought to broach, and we just talk about the practice of law in general and how it applies, especially with jury trials. So with the new simplified procedure rules, increasing the limit to $200,000 and eliminating jury trials, I think that's going to have a significant impact on especially the motor vehicle practice and slip and fall practice for sure. I mean, I'm already hearing plaintiff side lawyers in Kingston talking about salivating. They were hoping that the small claims limit was going to come up to $50,000, but even at 35, you're going to have a lot of your smaller, retired people who have experienced a slip and fall or trip and fall. You're going to see them run a small claims matter with much better margins for them. Then you're looking at the motor vehicle work, and we're going to see, I think, likely more and more non-trial work and simplified procedure trials for some of your motor vehicles. Now, there's pros and cons, obviously, on the plaintiff side to do that because you're not bringing your $1 million claims anymore. But certainly, it'll be interesting to see where we go in that regime.
No, I think the $200,000 will be good overall. It'll allow us to get things done faster. I think that's my biggest problem nowadays is that things don't move as quickly as they used to. I'm sitting here with counsel that I think gets it, but there's a lot of younger counsel, I'll be frank, that are not moving cases as quickly as they should.
Now, is it because they don't have the authority, or they don't know, or is it a combination of both, or the insurance company just, I
think it's all of those things.
Yeah?
Yeah, I think it's all of those things. I think that, and maybe even I think we discussed this off air a little bit, that it's people aren't getting trained the way they used to. You harken back to, we mentioned some names of these older fellows that we practiced under. It was a different time and era, and we learned how to do things. Basically, assess the case, and that applies on both sides. There's going to be a difference of opinion about what a case is worth, but we have an objective injury. We know what those cases are worth. Those cases don't need to go to trial if handled properly on both sides. So that's why I think if we have this $200,000 limit, it makes a lot of sense because 80% of the cases are going to be within that limit. So we can deal with things quicker and easier. And we also, I still tend to prefer jury trials. A lot of lawyers don't. A lot of plaintiff lawyers don't. And I think it's just because I was a defense lawyer for so long. I've done so many jury trials. I just prefer it. I'm more comfortable with that. So I miss that to a certain extent, but I think it'll help because younger lawyers that are having a difficult time making decisions will now be able to take guidance from what the judges are saying. Look at case law.
So are we getting rid of jury trials? Is that what you're saying?
Well, I think they're suggesting that for the new
simplified
rules. Yeah.
So everything under 200 is judge alone?
Yes. Yeah.
And you think that's going to be better or worse? Because a standard practice I understood for most insurers was you want a jury.
Yep. Yeah, immediately put in a jury notice on all MVA cases. So again, it's all a matter of what's claimed. So if you have a motor vehicle claim come in that's limited to $200,000, as a defense counsel, you're going to say, well, folks, sorry, we're snookered here. We're not going to get our jury notice in. The flip side to it is that there's trial limits. They've brought that down 5 days or 10 days, and I can't recall what it is. So they've limited your trial time and simplified. They've limited your discovery time, eliminated juries. So the flip side to it is you're going to be able, as a defense lawyer, to give your adjuster a very concrete cost budget to say, okay, our worst case scenario is $200,000 plus our cost of disbursements. Here's what it's going to cost because we are limited to this much time under this. And then, I think what you're going to see is a lot more business being done before or just after discoveries to say, okay, here's our goalpost. Let's get this stuff done.
So you're also going to be be very suggestive or very specific on the type of experts you hire then too, I would assume, guys. Because you can't, if you're limited to 5 days in total, you can't be saying, hey, we're going to have 17 witnesses or 17 experts. You got to pick the right ones, and they better be good.
And there's a limit on experts under the new rules.
I knew there was. Yeah. That's why I was saying it.
That just encourages common sense. That's basically what it's doing. And so I think it's a good thing. And this is something that, may not make, I'm not going to make friends with younger lawyers, certain people, certain firms, but defense lawyers are taking too long at discovery to begin with. I say that as a former defense lawyer. I can, even in the most serious of cases, I would be done in 2 hours. And yet I'm finding on small cases, objective injuries, a case that may be worth $100,000, I'm at discovery all day.
Oh,
Who's
so you're
paying-
saying
who's
the
paying-
length of time of the discovery, not
Yeah.
how many discoveries?
No, well, that too. I mean, people are trying to do a second discovery on cases that don't need it. I'm saying I think they're wasting a lot of the insurance company's money. Not my colleague today, but I'm seeing that in a lot of lawyers.
And
on
is
the
it
defense
because they
side.
don't know what they're looking for? They're just are they going
Yes.
fishing, or
I think that-
you
I
know,
think
for
the-
lack of a better words?
I think the problem is then it's harder for people to do trials. You know, I come from a time where they were more plentiful and the lawyers. But I learned how to do it. I've done the trials. There's a lot of these young lawyers haven't, and I think as a result, they're not getting the training that they need. They don't know what's important, what's not important. And I can't. Obviously, I'm on the other side of the table. They're not going to listen to me as nice as I want to be them. I have to just sit there and let them create these ridiculous transcripts that are not going to help them. You know,
So they're missing out, right? They're missing the key points. Is that what I'm getting from this?
Well, it's not even that, and John's quite right. You have to go through a trial or a dozen to really get a sense of what's important in a transcript. How am I going to use that transcript? And so many, and I see it too with some lawyers. You know, you throw them into their first discovery, and what they ought to do. One of the first questions I often get from some of my young colleagues is, "Do you have a script?" No, you don't. Not only do I not have a script, you don't use a script. That's half the problem. So many, I'll see them come in, and John's nodding at me here, where they'll have their standard questions and
Oh,
just
yeah.
go through.
interject one thing.
Yeah.
I was asked recently, and I'm a plaintiff lawyer, if I had surveillance of the defendant. Think about that.
Sorry, they asked, the insurer asked you?
Yes, the Insurance Defense Council asked my client, asked me, whether we had surveillance.
Surveillance of your own client.
No, of their client.
What? I don't even
Somehow it was in the script, I guess. I don't know.
Really? So just not follow, just in the questioning,
No.
just not thinking.
And going back, you sit down and you think of reviewing a transcript prior to a trial and looking for your inconsistencies. If you're going through a 500-page transcript full of dribble, you're wasting your time. And you'll do it once. I mean, as a young lawyer, you're going to go in, you're going to have, because you don't want to miss anything. Then you're going to do that trial, look at this stuff and go, why did I do this? And it's a learning experience, and you'll get better at it. So that's half the problem, compounding the fact that we aren't seeing young lawyers getting trial time. It's affecting their ability to practice in a more efficient manner.
Well, I can tell you from being on the insurance side, I've been to less and less trials as the years have gone on. I've been in the industry almost 30 years. And when I first started in the industry, I went to trials quite frequently and sat in on trials. And as the days have gone, I don't even hear about them, let alone know they're going on. So, I mean, I wasn't sure if they're just settling, or we're just not doing them, or what's going on, or these cases are just going on forever.
Well, the fact that we're doing fewer trials is not necessarily a problem because things evolve. And it's not a bad thing. If you have counsel on both sides of the table that respect the other side, respect the arguments that they're dealing with, and know how to assess a case, most cases don't need to go to trial. I'll be honest, in the 30-plus trials I've done over the years, most of those were a long time ago now, but they shouldn't have went to trial. I was on the defense side, and plaintiffs were, being aggressive on cases, and as a result, they lost. Most cases, we know what's going on, and you get into that right range, and you can so I don't think it's necessarily a bad thing that there are fewer trials overall. The bad thing is that you've got a bunch of lawyers that aren't learning how the sausages are made. And what my friend is saying is exactly true. That you get these people that don't know what happens at a trial, so they don't know what's important at a discovery. Really, you get all the paper before a discovery, everything you need to know to assess the case. Discovery is really just about meeting the person and assessing them as a witness. What's this person going to be like at trial?
And what's the judge or the jury's going to think about
How are they
them,
going to
right?
react to them?
Yeah.
And that's just being in the room with another human being and seeing what they're like. We do it every day. There's nothing special about that. Do I like this person? Do I relate to them? Do I think they're full of it? All of those things. And if we like somebody, the case is worth more if they come across as a good witness.
Sure, it's the likability factor, right? I mean, if you're just this angry person, I mean, your points go down, really, right?
Well, that's exactly it. And, so walking in there with a script of questions of, Well, the usual suspects of what talk to me from your head to toe. Where does it hurt here? Where does it hurt there? Well, you know that. Review the medical records. You've already reported out, or you should have reported out to your insurance adjuster well in advance of discoveries to say, here's the medical records. Here's what we know. We may be missing some additional records. You should be looking for those long before you ask for undertakings at discovery, and then assess the case going into the discoveries to say, we can spend this much money on a day or two of discoveries, or I assess the case here. Let's see what we can do to get rid of it. And that isn't happening enough. I think another consequence, and what I'm seeing, and people call me old school, even though I'm younger than, a little bit younger than John. Pick up the phone. Lawyer to Lawyer Communications would be a great podcast for us to have. Lawyers can easily take positions and pound out emails because it's easy. Pick up the phone, sit down, have that meeting, go tete-on-tete and see if you can settle it. I was saying to John off air, I happen to live next door to a former adjuster who, I'll say this, took off his white hat as the insurance defense guy and put on the black hat, moved into the plaintiff side firms, and is doing in-house adjusting.
Yeah, I know who he is.
Yeah. But we can sit in the backyard over a drink and walk through 3, 4, 5 cases, say, where are you at, where are we at, how have we assessed the case? And if the two of us are in the ballpark, then he's going back to his instructing lawyers, I'm going back to my instructing principals, and I'd say 85% of the cases we have together, we get settled before discoveries or just shortly thereafter, because
Yeah,
you can
can
have
you meet
those
in the middle?
communications. Exactly.
Right? I mean, the other thing that I find interesting is the whole thing about the script. I mean, I've had people ask me, you've done all these interviews, what information, like what is the script that you use? And I say, it's tombstone information. And they were like, what? I asked them their tombstone. That's the only thing I can tell you that is scripted. Name, address, date of birth, where you live, phone number. Beyond that, it's all about how you interact, right?
Well, it's about communicating. You want to get in the room. The big problem a lot of these lawyers make is that they're reading a script and they're not even looking up at the person. It's about having a conversation. Be in the room with the person and meet them. You wouldn't buy a car from somebody that you didn't look in the eye. So why are you trying to assess what somebody's case is worth without getting a sense of the person as a person?
So, guys, this sounds like it's going to be a great podcast. I'm looking forward to it. Believe it or not, we've blown through 30 minutes here, and pretty close. And so we're almost at the end. Let's touch on some things. We've talked about what we're going to, we're going to talk about. I think we should talk about the changes in the limits in small claims court and those as well, like simplified rules and the changes there. Let's talk about that as a podcast. What else do you think we should go on?
As a suggestion, do you have social media out to the members? Like, why don't you put a question out there and let people ask the questions?
Yeah, let's do that.
We'll talk about whatever topics they suggest.
Yeah, I mean, we're on once a month. We've got a full year of doing this. It's going to be great.
It's hard enough to get people to listen to lawyers. We're boring enough. So if that happens, at least if it's topics that we know people are interested in, maybe we can.
Sure, I think we need to talk a little bit about AB. I mean, that's always a hot topic. I was talking with a doctor here just before lunch, and adjusters heard that, psychologist, and immediately sat down. So they want to hear about, the stuff that they're doing. And I think that AB is always a hot topic. I think we should definitely talk, like I said, the changes in the limits, and we should talk about, we should really just talk about the changes in how things are being done in the industry from both sides. I like that, the plaintiff perspective, the defense perspective, and I definitely will put it out on social media and ask people what they want to hear.
Yeah, I think that's a great idea, and John's quite right. We could sit here and talk all day long about certain cases and go back and forth on it. It may well be more interesting to lawyers, not so much for adjusters. So, yeah, I mean, even breaking down, I can throw some topics from my own perspective in dealing with various adjusters. We can talk about, John and I were talking off air about sometimes some of the problems with settling these cases. Why does it drag on so long? And sometimes a lot of that has to do with adjuster burnout. we aren't talking about, with the lawyers of, so many adjusters are getting buried with so many cases, and they're going to either depend on the lawyers to make a decision to tell them here's what this case is worth, or they're just going to be left fledgling. So we can, give some insight into adjusters and the change in the industry there and what's to happen there. But yeah, no, I think we can be wide open. I think based on how we've flown through the last 26, 27 minutes on sort of one topic, I think we're going to be able to fill our time pretty good.
Oh, absolutely. And the other thing I think and you kind of touched on it there, is the file's getting transferred within the insurance company. You're dealing with adjuster A today, and then it's adjuster B next week, and they're always trying to catch up and learn what the file's about. I mean, it's a little easier now because most people are paperless, but in days of old, you had to physically read the entire file, and sometimes it's accordion files and boxes of information, because these cases don't settle sometimes for years.
Yeah, I think that's a big problem, adjuster turnover, and it's a bigger problem on the AB side. It just seems like every 2 months there's a new adjuster. But on the tort defense side, it's an issue, and I think, I don't know if I'll say the insurer that did it, but a good idea. When I was a defense lawyer, one of the main insurance companies I used to work for wanted the adjusters to be involved in the case at all times. So the adjuster could get involved and approach plaintiff counsel before discovery, after discovery, and try and settle the case even on their own. And I think that's a great thing, and it's something that we try and bring with us as our model on the plaintiff side. We have former adjusters that work for us, and when we're dealing with the case, we know often now that adjusters don't have the authority to deal with something before it goes to counsel, but we make that connection with them, give them an idea about here's where this case is going, here's what we think, we'll see you on the other side, hey, why don't you call us before discovery yourself? Now, some insurers are not allowing them to do that, but I think it's a good thing to keep that communication open with the adjusters through counsel. But let's all get together. The only time, we shouldn't have to wait until a mediation to talk to the adjuster is what I'm saying. We can set up with counsel, let's set up another discussion. Like my friend is saying, let's just
Talk.
talk.
So, guys, typically when I'm doing these, I'm talking to insurance people. So, Mike, on your side, it'll be easier. John, not so much. So, but if they need to reach you, Mike, and find out about retaining counsel in Eastern Ontario, basically Port Hope to the Quebec border, how do they reach you guys? I know you have multiple offices. Is there just a central number, a central email?
Sure. So you can always email me. Very easy. First initial, last name. So mswindley at tmlegal, like TomMaryLegal.ca. And if you can't remember that, just think swindle and put a Y on the end of it. I was an appropriately named defense lawyer, I think.
Nice.
Maybe a betterly named plaintiff's lawyer. I don't know, John.
So, and John,
Some lawyers, not me. That's not our approach.
so John, for you, I know you're super approachable because I've dealt with you when you were on the defense side and on the plaintiff side. So, John, how do they reach you if they want to talk settlement, or they just want a plaintiff's perspective? I mean, we've never really approached a plaintiff's lawyer for plaintiff's perspective, but there's nothing. I don't think there's anything wrong with having another point of view.
Well, there's not, and I thought about, this might be self-promoting a little bit, but everybody inside your circle of care as an adjuster, they're going to turn to you if they're in an accident. So the way I look at it is, they need a lawyer. Well, why not have a lawyer that you respect, a lawyer that used to do what you did that's on the defense side? So that's my pitch and my marketing when it comes to that as well. But I do encourage, once you're involved in a file, even just the courage and the handling of it, contact me. I mean, speak to your lawyer about it, obviously. You don't want to be making a run around your lawyer, but you can approach us. And we're the easiest firm in the world to get a hold of. It's pound 1000 is our number. It's the easiest thing to remember. You just hit pound on your phone and 1000. We've got a phone number. We've got a million other phone numbers, and you can get me at john.russell@Diane Russell. Just remember Diane Russell or pound 1000. Put any of those in your phone and you'll get it.
And for the young people here, look for the hashtag sign. John is really dating himself with pound.
Yeah.
It's hashtag.
Is it hashtag?
It's hashtag 1000 or pound 1000. People
Or the
older
number
than,
sign 1000?
Yeah. People
I think
older,
actually it's Omorato. Is that the actual Latin term for it or whatever? Yeah.
But it's people over 40 say pound, and people under.
That's right.
So millennials is hashtag 1000.
That's right.
And everyone else, pound 1000. Well, thanks so much, guys, for being on the show. I mean, it was just more of a meet and greet today. I appreciate you guys, and I respect you both very much. And I look forward to the next 12 months working with you guys on this podcast.
Thanks, Terry. Thanks, John.
Thanks, guys. Thanks, Mike.